Ladies and gentlemen, if I can again ask you please to just make sure that you use the chat facility, which is at the, I'm not sure on your screen, but it's actually a bubble. So you'll be able to type into the bubble, and in the process, you'll be able to ask questions that I can then read and that I can then respond to. Thank you all so much for attending this session, and I am going to hope to be able to keep it to a 45-minute session. I know I normally say half an hour session, but I'm going to hope to keep it to a 45-minute session. SAITA is the South African Independent Tenants Association. And this is a meeting of SAITA specifically to talk about the response to PIG, which is uh, um, the property group, which is a combination of three associations that recently put out its proposal to the retail tenant industry. We are talking here about retail tenants. So that is why we are looking to respond to the PIG proposal in its entirety. My name is Ivor Blumenthal, and I was actually sent a message to ask me, could I please just explain who I am and where I come from? So SAITA, the South African Independent Tenants Authority, or association, was created in 2014 as a loose association, not a formal organization, but association representing independent tenants. And my background is that I've spent the last 25 years building business associations and business confederations and representing the business community in a variety of ways. But I've also been a tenant myself in several shopping centers around South Africa, three here in Gauteng, two in the Western Cape, and two in KZN.
Please can you
So I
turn the
have
other
a
mic
regular
off?
share of dealing with landlords and particularly managing agents. Um, this particular round of SAITA membership is about asking you as independent tenants to understand that you need to be responding to landlords in the time of lockdown, and responding collectively as a group. And so that's what SAITA is. It's a group, it's a collective group representing the interests of independent tenants who very often don't have the resources that the very large retail groups would have, and particularly the legal assistance and the relationship with managing agents, as well as the relationship with as well as the relationship with landlords. Leah has asked, can you please switch off your microphones? I am going to try and do that from my side. I'm going to unmute. Sorry, I'm going to mute. I'm going to mute everybody's microphone because there's no reason for you to talk. What I'm going to ask you to do is I'm going to ask you to type in any of your comments into the chat line feature so that we can keep this meeting orderly. All right, so let's get to it. What I want to talk today about, and we spoke about at the launch of SAITA last week as well, I want to talk about the current legislative framework under COVID-19 for landlords and tenants, because that has an impact on why we're able to talk to each other, and has an impact on why landlords are in fact able to talk to each other and why they were able to come together as the three largest property groups in South Africa to create the proposal that we're going to be covering today. I want to talk about our strategy for dealing with landlords, both for you as an individual tenant, as well as groups of tenants in one particular center. And then I finally want to talk about our strategy for dealing with municipal councils. Then we're going to look at the actual proposal, and then I'm going to talk about our response, which has been circulated. Maybe not to everybody, but it certainly has been circulated for input and for comment. And I do want to talk about some of those comments as well. So let's get to it. And thank you very much for joining me. So just very briefly to tell you that government has gazetted new regulations that will allow competitor malls to negotiate between each other with retailers and restaurants to lower rents and offer rent holidays. Ibrahim Patel said at a press briefing that many shops and other businesses in shopping malls have already seen a decline in their turnover. They face significant fixed costs, including rents and costs specified in leases. My concern is that Ibrahim Patel has only been speaking to landlords and to managing agencies. Nothing in anything that has come out from Department of Trade and Industry has in any way reflected any benefit for independent tenants whatsoever, except the serendipitous benefit that in what is called a block release, where he lifted the competition laws which prevented shopping centers from talking to one another. And if you want the seeming collusion between property owners, the serendipitous benefit of that, the other side of that coin, is that tenants, therefore, would be able to talk to one another, whereas previously it might have been construed as collusion. So that block release has given us this opportunity now to have these discussions that ordinarily under competition law in South Africa, we might not be allowed to have. His regulations enable tenants who are competitors to meet and to reach agreements with shopping mall owners and to address matters such as payment holidays, rental discounts, and limitations on evictions. The new regulations will also allow for the suspension of clauses in lease agreements that
Sorry
restrict
to interrupt, but can Amit please turn off his
reasonable
microphone?
required to protect viability during the national disaster. So we are today, our proposal today is based very much on that statement by Ibrahim Patel, that his regulations will allow for the suspension of clauses in lease agreements that restrict you from undertaking reasonable measures. And what is a reasonable measure? Well, if you're locked down and you've got no income, one principal reasonable measure has to be that you can, in fact, look at some kind of withholding of your rental payments to protect your interests, to retain your relationships with staff, etc. There's someone called Amit. Amit, I'm going to look for you online because you apparently keep talking, and because your microphone is on and you haven't suppressed your microphone, apparently it's causing people out there to be distracted. So I hope I've managed to find your microphone. Thank you for that. Okay, good. Initially, only restaurants, personal care services in malls, as well as clothing, footwear, and home textile shops would be included in the regulations. As far as we're concerned, as far as SAITA is concerned, whatever other businesses there happen to be in malls that are in lockdown and are our members will be protected by the same block release. And the Competition Commission must try. They must try and come after us because we're talking to one another. When these measures have been taken for everybody else in shopping centers, they will literally be in the Constitutional Court for the rest of their lives. Okay, so one of the things I want us to do in the course of today's discussion is we have to, ladies and gentlemen, be talking about our strategy as far as one tenant to a landlord is concerned, multiple tenants to landlords are concerned, and then multiple malls to one landlord is concerned. Sally asks, have PIG not revisited the original proposal since lockdown extended to end of April? Not that we're aware of, Sally. There's been absolutely nothing that's come out from PIG, but really that proposal was extendable, if you want, for the period of the lockdown. It's not unrealistic to read it as for the full period of the lockdown. Good. If there are any questions, like some of you have been doing, please just feel free to type those questions into the bubble, and I will be able to read them. I'll be able to answer them. Now, just to remind you, ladies and gentlemen, that SAITA's strategy as far as landlords is concerned is that you're, as tenants, not being able to use facilities for their intended purpose, and landlords continuing to bill you for rent and not relaxing those rental requirements, that amounts to what we refer to as unjust enrichment. The landlord basically wanting to make his margins, despite the fact that the whole reason his tenants or his customers have literally bought the space or leased the space, despite the fact that that space is no longer available for the same reason. That is referred to as unjust enrichment. And SAITA will take a very, very heavy stance against unjust enrichment of any landlord in this regard. Our strategy is to look at splitting the rental invoice between rent and services, and we're going to talk a lot about that. We have an argument for reduced rental, which you're starting to hear. And we also have an argument that in the case of deferment should be very narrowly defined as payments which might be required, which relate to these services, rather than necessarily the rental requirements themselves. I think what's important is that you will always be told if you are litigious, you will always be told by your lawyers that it very, very much depends what's in that lease agreement. The reality is lockdown is something that is extraordinary. It hasn't been anticipated in your lease agreement. And specifically because of what Ibrahim Patella said in their block release, you're entitled to take reasonable measures to protect yourself and to defend your business. All right, so moving on. What we will be doing as SAITA down the line is there will be some landlords who are simply not going to see reason, some managing agents who have convinced landlords that it's not necessary to see reason, and therefore it might be necessary down the line to become litigious. In other words, to get into the legal side of things with both those landlords and those managing agents. If that becomes a necessity, then on a shopping center by shopping center basis, we will look to retain independent legal counsel. And it's very difficult to find independent legal counsel, the kind of people who haven't represented landlords or managing agents before, those types of lawyers to draft legal papers who are at least neutral, if not advantageous to independent tenants. As I say, it's very difficult to find independent legal assistance in this regard, but they are out there, and we have been building a database of them. We're hoping not to be able to have to use the database, and we've seen that with a number of landlords. There have been exceptional offers, but those offers have never been made on a block basis to all of their tenants. They've been made on an individual basis to the tenants that they value rather than to all of their clients throughout their shopping centers. But the most amazing things, I mean, for example, yesterday I heard of landlords have said, don't pay us for April, don't pay us for May, and if it extends beyond, we'll make a plan with you. I mean, that's amazing. And those landlords have to be acknowledged and they have to be appreciated. But equally, ladies and gentlemen, I think that the guys who are absolutely litigious, the guys who tell us that we've got no choice but simply to resort to the lease, those are landlords that, quite frankly, I think it would been very necessary to counter and to tender alternative arguments to. All right, so let's move now to the property industry group. Now, the property industry group have tabled this proposal that you've all seen by now. The property industry group is a group that was made up of, it's a confederation, it's an informal confederation that is in fact composed of the South African Council of Shopping Centres, the SACSC, SAPOA, South African Property Owners Association, and SA Right, which is another property owners association. It's sometimes difficult to see the dividing line between SA Right and SAPOA and SASCC because the members are common between those associations. But they've created this structure called the Property Industry Group, and it announced its retail tenant assistance relief package about 7 days ago now, on the 7th of April. Now, I think what's important, and I want to actually go through their paragraphs to read them to you so that we can actually see what their intention is. The group has announced an assistance and relief package for the retail sector to provide support to those that need assistance the most. Although its primary focus is on SMEs across all sectors, the group has also included providing support to large retailers affected by the lockdown. In reading their proposals, in looking at the nature of their proposals, it is very, very clear that what they have indeed done is not create a series of proposals which are pro-SMEs, but rather create a series of proposals that will pander to the very large retail groups within their fold. These proposals are almost exclusively skewed towards the retail groups like Fashini, etc., etc. Those retail groups that have come out, Pepkor, and said, you know, we're not paying you rent, and we actually don't care what you do. So while they are saying that this PIG response, property industry group response, is to the SMMEs, it really is not. It's to the large groups, and it's pandering to those large groups. They say that the initiative targets preserving jobs for retailers, their suppliers, and service providers. Well, in fact, it doesn't. what it does do is it creates a long-term liability for all independent tenants. And we'll talk about what that long-term liability actually looks like when we talk about their proposal. To qualify for the relief benefits, retail tenants will need to undertake not to retrench staff during the relief period. Well, in fact, what they're doing here is they're simply repeating what the law says. The law says that you're not allowed to retrench people during the lockdown unless you've got a Section 189 process that preceded the lockdown, where in fact retrenchment was a possible consequence of that Section 189 process. So the proposal by the PIGS group that says that it's their proposal which will prevent you from undertaking to retrench staff is just not true. It has no effect on your decision to retrench staff, and they cannot make it contingent because you have no intention of retrenching staff because you're not going to break the rules and you're not going to break the law. The package stipulates that all tenants whose accounts were in good standing at 29th of February can be assured that there will not be any evictions for the next 2 months. Now, this is the most dangerous. This is the most dangerous component of the entire offer, ladies and gentlemen. And you need to understand that. Because what they are basically saying here is that if you haven't paid your bills, you're not fully paid up for the 29th of February, remembering, of course, that rates and taxes are retroactive, that when they bill you for rates and taxes, they're going back to the February-March period, maybe even the January-February period. What they're saying here is they're buying an out for themselves for all of those companies that had outstanding disputes with your managing agents or your landlords, where you'd short paid or refused to pay because an issue on your invoice was in dispute, that they would be able to apply for your eviction. Well, in fact, they're not able to apply for your eviction, even though they would like to. And they're asking you to sign an agreement here, which would basically make this new law, because this agreement would then empower and entitle them to take actions against you for evictions where you are in arrears with them in any respect. There is a staying of the right for this kind of thing, and particularly evictions, to happen at this moment in time in terms of the spirit of what was announced by the Minister of Trade and Industry. What these landlords are trying to do is they're trying to ask you to circumvent any of those government gazettes or directives by the various government departments so that they can then continue to take action for evictions where they want to in their relationship with their managing agents, because you would have then given them permission to do that. So that's critically important that you understand that paragraph. They say, in addition, retailers prevented from trading in compliance with South African government mandated lockdown, in other words, non-essential services, and in good standing at the end of February 2020, are offered some form of assistance from landlords. Some form of assistance from landlords is very telling again, because while this is an indication to their members of what they would like their members to be offering, it is not a directive. They have no hold over their members or their associations, so they cannot therefore tell you that the companies that are their members, the property owners or the shopping centers that are their members, will in fact be guided and directed by these indications. We're very concerned. I particularly am very concerned about the discretion in terms of landlords being able to decide about the severity of impact of the lockdown on your business, because that opens up a whole new can of worms in terms of licensing the landlord to audit every aspect of your business, your books, your annual financial statements, your management accounts, to determine how severe the lockdown has been or is going to be on you, and then to determine what sort of remedy they'll want to apply. So I'm being, as you can see on the chat line, we're being told that Fashini and the clothing groups, yes, we know the clothing groups have entered into an agreement where they've tendered 20% of rentals, and that's it. And so basically they've set a standard for us to follow. Dis-Chem have said they're not paying at all, but I think Dis-Chem will eventually come to the party, but in terms of the same kind of agreement. But as you can see, this PIG announcement, the Property Industry Group announcement, has directed the ongoing negotiation activities of the large groups. it's not directed towards SMEs. So even though they say it's directed towards SMEs, it's got nothing to do with SMEs. So they say, for April and May, retail landlords will offer relief in the form of rental discounts, where rental will be waived partially or fully, and interest-free rental deferments, where the deferred rental will be recovered later over 6 to 9 months from the 1st of July onwards. Now, we know that some of you have already received letters from your landlords that have said, if you want us to defer April and May, we're quite happy to do it, but ultimately we're going to ask you to sign a new 3-year lease as an extension of this current lease agreement. That's one thing that's happened. They say that rental includes rent, operating costs, and parking rental, but excludes all rates and taxes recoveries and utility cost recoveries. So when we talk about distinguishing your invoices into two parts, we're really saying the one part, which is rental, which will include rent, operating costs, and parking rental, and the other part, which includes rates, taxes, and utility cost recovery, as well as insurance, which all tenants are required to pay in full for April and May 2020. If currently you're not paying insurance on your existing bills, your existing rent statements, then in fact, this doesn't provide an opportunity for shopping centers to now add insurance on so that they can alleviate their insurance costs by passing that on to you, the tenant. That's something you just need to be aware of from the get-go. Mike says, Marinda says, can the landlord actually scrutinize our accounts? Do they have the rights? Marinda, if you sign a PIG agreement, I hate that term, but it's their term. If you sign their PIG agreement, then in fact you're giving them license to determine severity of impact. They can ask anything from you, but certainly they would ask for at least your management accounts, if not your annual financial statements, so that they can actually see where your income has gone and what you've been spending your money on. There's no question they could do that. In a couple of cases that I'm aware of, they have asked for those documents. In a lot of cases, they haven't. It says each landlord can use their discretion in the relief and assistance they give a retail tenant, but the property industry package stipulates the minimum that qualifying retails can expect. So what they're saying, what the PIG group is saying, is that what's contained in their agreement here, or their offer here, is the minimum they expect their members to abide by. Most of those property associations have agreed to abide by these minimums, but obviously they now have to convince their own members to abide by the agreements. And we've seen that the majority of large landlords have been communicating directly with the tenants they want to communicate with. And a lot of that communication, no, let me be generous and say a lot of that communication sometimes has been very favorable, more favorable than in fact the PIG offer has been, more favorable than in fact the offer has been from the property industry group itself, I must say. And I say that unabashedly. So I mean, there are strange inconsistencies amongst landlords, but also, I suppose, between landlords, that need to be addressed along the way. Some landlords are being more than generous, extremely more than generous in these activities, which I think is interesting. But it doesn't really help us when they're being generous towards how can I say, they're being generous towards particular tenants, but not all of their tenants in the process. Landlords will, on a case-by-case basis, also consider providing relief for office, industrial, and hospitality tenants where the lockdown severely impacted on the tenants and where it is justified. So for those of you who are commercial tenants, in other words, you have office space or industrial space, space not basically covered generally by what a retail tenant is, know that you're covered essentially by these agreements, by this proposal, although they say that these tenants will negotiate relief directly with their landlords. Shopping malls accommodate a wide variety of retail tenants affected by the lockdown, and when putting together the package, they say they engage with various groups of retailers to get their buy-in. I can tell you, I've now spoken directly or indirectly to over 500 retail tenants across the country. Not a single one of those retail tenants were involved in the consultations that the PIG, the Property Interest Group, consisting of SAPOA, the Shopping Centre Association, and SA Rates, that they say they've actually engaged in. So we do not know which retailers they've actually spoken to about the fairness of their proposal, whether the proposal is hitting the spot or not. But it's certainly not SAITA members. It's certainly not independent tenants. In fact, I would like you, ladies and gentlemen, and there are 84 of you on this particular discussion, if you have been consulted as to what this PIG agreement should look like and the contents of the PIG agreement before it was published, please, could you just indicate that on the chat line? We'd really like to know. Okay. So they say that the package comes at a massive cost to the property industry, which faces its own challenges, but is necessary, etc., blah, blah, blah. The package assumes the SA's lockdown won't extend beyond 21 days. Well, it does extend beyond 21 days. So it wasn't a bad question, by the way. Please, I know that I glanced over your question. Who asked that question? Who asked that question? Sally asked that question. Sorry, Sally. I really, I glanced over your question. I shouldn't have glanced over your question because something occurs to me now that didn't occur to me previously. This PIG agreement expires in 2 days' time. So the property industry group indication that we're now going to talk about actually expires in 2 days' time and hasn't been extended for the balance of the lockdown. It doesn't indicate that there is an extension for the balance of the lockdown. So I think that that's something that we need to consider because after I've discussed their proposal here, I'm going to talk about our response to their proposal, or at least the draft response. And I know there are a lot of you have had a lot to say, and that's fantastic. We really appreciate that. I'm just reading some of the comments. Okay. So the bottom line is that the 21-day period is critically important. We make a response. The response is directly to the landlords. The response I've received from 2 members of SAITA so far is, don't jump the gun, don't be aggressive, wait for them to come to you with their proposals. Now, the reality is, if they come to you after the 16th with a proposal, whatever they come to you with is not going to be covered by the PIG proposal anyway, the PIG guidelines anyway, because they haven't been extended. But that doesn't mean to say that the landlords won't, live their lives by the PIG guidelines. It just means that it has no force and effect what we're going to be covering now in terms of the specifics. My philosophy is this. You know that you're going to need to have a relaxation by the end of April. We are halfway through the month of April now. I honestly, ladies and gentlemen, do not believe that we are in any position whatsoever to wait for our landlord, to hope that our landlord is going to come to us with some kind of a benign proposal in our best interest. It has happened on a couple of occasions, but what I think I can guarantee you is that the landlords have now spoken to the tenants that they value enough to want to protect them above all else in the shopping center. So that there are tenants that are so valued that the landlords have come to them and said, we understand what you're going through. We want you around for a long time. And therefore, we're saying to you, certainly for the month of April, you don't have to pay us any rent. And for the month of May, if it's extended, you don't have to pay us any rent, but you'll pay us, all the rates and taxes and services, etc. So I can virtually guarantee you that the landlords and the managing agents will have spoken to the tenants that they value by now. They certainly have spoken to the large listed groups, as we know, and those large listed groups have already entered into agreements with those landlords, but they've not spoken to you, the independent tenants. So personally, I feel that this argument that we should wait for the landlord to come to us is going to get you into trouble. And more importantly, it's going to come to you at the last moment where you're not going to have the opportunity of negotiating. My feeling is that you should be approaching your landlords either collectively, and we're planning collective responses in a number of shopping centers already, and I'm happy to work with you on a shopping center by shopping center basis. But if you approach as a collective it is less likely that your landlord is going to be able to bully you and your managing agents are going to be able to bully you the way they traditionally would bully. And I'm generalizing because there are exceptions where that would never be the case. But traditionally, the way they would bully independent tenants. Um, Sally Firth just says something that needs to be noted. I am sure that a lot of SMEs like us have got signed debit order authorizations with their landlords in place. So April rentals already been deducted in full. We cannot unilaterally cancel these debit orders with the bank. What recourse can we take and how do we handle that for May? Well, Sally, that's a very good question. The reality is that your April debit orders, when we say April, by the way, we're saying end of April for May, but those debit orders, if you write to your landlord and say, please, I need you to cancel my debit order, even if they don't come back to you, and then that letter and that just email receipt of what you've sent to your landlord, you take to your bank, you can give your bank an instruction to cancel that debit order, and they have no choice. They have to cancel that debit order. That's just how you technically deal with debit orders. But the reality is, even if the debit orders go through, our recourse will be to set off against future invoices at the very least, giving us more time. If we find a situation where a bank says to you, we're not dealing with you, we're only dealing with your landlord, then in fact you have a recourse to the banking ombudsman, and you have a recourse to the Competition Commission, and you have a recourse to the Consumer Commission, because then those banks are in collusion with the managing agents and the landlords. And SAITA would be only too happy to take that up on an individual or a group of individuals who, in fact, are having those problems with their banks. Only too happy. Um, Bernard said, is now not the time to rewrite how lease agreements are drawn up for SMEs? Bernard, that's why we're here. This lease agreement template has to be used by all landlords for independence. This could be a long way from negotiating bullying. Bernard, you are so completely correct. And that's why SAITA has been created, to create a new framework, a new enabling legislative framework for independent tenants in this country. For a long time, SAPOA, the South African Property Owners Association, has been the sole lobbying arm at the Trade and Industry Portfolio Committee in government on behalf of property owners in the country. There's been no voice for independent tenants. And so all of these agreements and leases and the law behind these agreements and leases, and that's why it's so difficult to find independent lawyers, because they all work for the shopping centers, managing agents, and the landlord. But all of the law has been based on the interests of the property owners, and none of the law has been based on the interests of tenants. The argument by parliamentarians who are in the pocket of landlords and managing agents is, well, small businesses can go to the Small Business Development Ministry. They can go to Trade and Industry as small businesses. They don't need protection. The landlords and the property owners, they're the ones that need the protection. And that's why Parliament has always rallied behind property owners and landlords, and municipalities have done likewise. And so, Bernard, in answer to your question, unless we stop it now and send a message out to Parliament now that we want to sit and we want to renegotiate in the best interest of the small, medium, independent tenants, then in fact nothing is going to change. And I'm sorry to sound so hard. I hope it's just passion coming across rather than me sounding hard. This thing that Chris says, you're not allowed to dispute a debit order in any event. Chris, I give you my word that SAITA will take this up with the Banking Council. We will take it up with the Portfolio Committee in Parliament. And any bank that is found by the Competition Commission to be colluding with landlords and managing agents and disallowing you to discontinue your own debit orders, we will put together a group of independent lawyers who will be prepared to fight this fight for you. It's just that it hasn't been fought up until now for you. And as the small person, your bank completely disregards your interest. I can tell you that as for what it's worth. But we'll have a different discussion in a different webinar about how we create a new dispensation with banks financing houses and, in fact, government as groups of independent retailers. We can't do that on this discussion. Okay. I just want to get to some of the more important components of what it is they're proposing. Okay, so just before we talk about what they're proposing, they say this. It is important that business, labor, government, banks, and other investors take decisions that don't jeopardize the country as an investment destination, all that kind of gump. What they're basically saying here is that they don't want governments or banks to jeopardize them as shopping center owners in terms of their margins. We believe our approach provides a level of certainty in the sector they do for property owners and protects an important part of the economy, which is the shopping centers, at a time when we most need that. And our options are quite limited, says de Klerk. Well, their options are not quite limited because, in fact, if they'd spent as much time as they're spending in pandering to the large retail groups and ignoring the interests of the independent retailers, if they'd spent as much time raising facilities with banks, the Banking Council, and even the Department of Trade and Industry that would have bent over backwards to give them those facilities, they could in fact have bridged these losses that they're incurring now far more easily, and having access to finance far more easily than you as an independent tenant ever could have done or even could do now. So I think they're disingenuous when they say that about their options being limited. It's just that they don't want to sacrifice margins and they don't want to have to dip into their capital to cover their losses. Every one of you has told me, that has spoken to me, of how much you've had to dip into your own capital, how much you've actually had to spend your own money, neutralize the benefit of your own savings to cover these losses, to continue paying your staff, to continue paying your suppliers where you can. And these landlords have the audacity to say they don't want their margins or their share value affected. And that's what they're trying to protect here. It really is quite disgusting, I think, but I'm really only talking for myself. Okay. And I say that there are some fantastic there are some fantastic case-by-case stories I'm hearing from landlords who in the one instance are bending over backwards for some tenants, but on the other instance are treating tenants with total disregard. It's sometimes very difficult to understand. I think that the problem is not the landlords. I think that the problem is the managing agents, in fact. And so what's happening is that the managing agents, which create a barrier between themselves and the landlords, with you, the tenants, those managing agents are playing God and deciding which tenants should be protected above all costs and who shouldn't. If you've had a run-in with a managing agent previously, I think that you can consider your days to be numbered in that shopping center, because this is going to be the opportunity a managing agent uses to marginalize you and to get you out of that shopping center. I'm seeing this again and again and again, and I'm hearing these stories again and again and again. Okay, so let's look at their proposals. SMME retailers categorized by the DTI as having a turnover of up to 80 million rand. So the Department of Trade and Industry says that the minimum category of business that we're talking about here is a business that does 80 million rand turnover. Now, that already tells us something, because how many of you, I'm not talking about in a group of stores, how many of you individually in your business does 80 million rand of turnover? The reality is that from what I'm understanding, the average SME turnover amongst independent and retail tenants is anything from 5 million to 10 million rand and maybe up to 20 million rand. In other words, if we had to put a ceiling on it, let's be gracious and say 30 million rand. 30 million rand is nearly a third less than how the Department of Trade and Industry and the property industry group classify small businesses. Now that's already telling you that what they are intending to do with this relief is push this relief to the larger retail groups, what you would consider to be the larger retail groups, the medium retail groups, rather than yourselves, who are incidental, but in fact the only people paying 100% of your rent on an ongoing basis. And I do want to say that as well. Understand that the vast majority of destination stores in your shopping center pay nothing like what you pay per square meter, pay nothing like the rent that you pay for the space that they've got. And the formula in the shopping center is to use you, the small independent tenant, to subsidize the larger destination stores that very often will dictate terms to the landlord, not the other way around. In fact, all the time will dictate the terms to the landlord, like not the other way around. Practical example is if a large destination store wants to come into a shopping center, they will say to the shopping center, we're not going to pay you anything in rental for the next 2 years, because that's what it's going to cost us to recover our setup costs. And when we start paying, you will start at 20%, and gradually over a 5-year period, we'll move up to 100% of what you might want. That's the kind of negotiation that takes place. Now, imagine you trying to negotiate that kind of dispensation from your landlord. Some of you might have, but the reality is no. There is a comment that says, I'm a dentist with an annual turnover of 2 million Rand. Well, Mr. Desai, they're saying to you, you should be making 80 million Rand. So what's wrong with you, basically? There's no classification for you as far as these guys are concerned, and their relief certainly doesn't stretch to you. But let's look at what their relief is. They say that those highly impacted retailers, for example, companies selling time and services such as restaurants, hairdressers, travel agents, takeaways. I wonder how many of those do an 80 million Rand turnover. For them, the basic assistance and relief is 35% to 100% of April's rental, and further potential relief could be in the form of rental deferments. So interesting that some of you have already posted to me that Foschini has entered into this 20% of rent agreement. We don't read 20% here, do we? So we can already see that this group has broken their minimums down from 35% minimum that they're prepared to offer to 20% that's already been negotiated with them by the Foschini group. And then, of course, them saying to you that, there could be further potential relief in the form of rental deferment. So if you do have to pay that 35%, they might be prepared to defer that 35% over a 6 to 9 months from the 1st of July. Ordinarily, this is a good offer. I just think it comes from a place of mala feeders towards the small and independent tenant, but it's generally a good offer. They say May, up to 50% of May's rental and further relief. Now, the reality is that if they change this agreement, it would be April, and it would be May for those prepayments. But in all likelihood, this component of the agreement wouldn't change unless we know that there's an extension into May. At the moment, our extension is only for the April of the lockdown. Level 2, medium impacted, companies selling products that don't have a limited shelf life. The same kind of relief, except they're saying that with the companies that don't have the limited shelf life, they're not offering 50% for May. They're only offering 25% discount for May, and the rest in rental deferments, which will be paid over 6 to 9 months. So here's a question to you. And certainly this is one of SAITA's negotiation stances as far as I'm concerned. And please, I'm asking you to understand this point because it does really, really impact. If I am deferring 1 month of payment, why are there some landlords asking me to, in fact, extend my lease by a year in exchange for that deferment? In other words, there are some landlords saying, fine, we'll accept we'll accept the PIG indication and we'll allow the deferment to be split over 6 months or even 9 months. But we are insisting at the same time that the company will need to sign a 1-year lease extension. In other words, I'm going to get 12 months back for the short-term cash flow sacrifice I'm having to make over a 1-month period. It's absolute unjust enrichment as far as SAITA is concerned, and they would never dare saying that to a large retail store or a group of retail stores. Now, what's important here are their caveats. Tenants' financial position and strength of balance sheet to be assessed by landlords to classify in the impact category. This is what I was saying earlier to you in response to the one question, that to classify in the impact category, they want to see all of your financials. Landlords have flexibility and discretion on a case-by-case basis to adjust parameters. However, minimums are set as the base guideline. Well, that really means nothing here because these base guidelines only last for 2 more days. Landlords have flexibility in normal or better trading assessed considering rent to sales ratios, balance sheet, stock availability, etc. So they are really asking you for everything about your business for them to make an assessment of the kind of relaxations they're going to give you. Ladies and gentlemen, I do need to say this to you. Look, you should have this information available anyway. Your point of sale system should give it to you in a very rudimentary way. Your accountant or auditor should certainly be able to give it to you. But you need to know what your rent to sales ratios are. And there are a variety of ratios. And if you want, by the way, we can actually I can get someone to run a webinar for us through SAITA, specifically on understanding those rent to sales ratios, what your landlord would want to see in your balance sheet, and from a stock availability perspective, how you should be presenting your stock to your advantage rather than necessarily to your landlord's advantage. That's quite intricate. It's the kind of thing that your accountants or bookkeepers should be doing for you. But if they're not, you need to understand it. And seeing as we've got time on our hands for the period of the lockdown, it might not be a bad idea to run 1 or 2 webinars specifically on those issues anyway. If you do want to do it, then please send me a note on WhatsApp or on the WhatsApp group, and we'll consider running those webinars. But you have to have that information as far as your landlords are concerned in terms of this offer. Non-essential good services. Now we get to the really tricky parts. So forget about the fact that they're not giving any kind of dispensation to state-owned enterprises and government tenants. But all retailers with annual turnover above 80 million, now that's above 80 million, including local and international listed publicly traded retailers and large unlisted companies, they're offering 35% discount and 15% deferment. So they're saying you've got to pay us 20% rent. We'll defer 15% rent over a 6-month period from July, and we will then give you the other 65% as a discount. We'll reduce your rent by that other 65%. So when you look at the agreement that Vashini has signed, that many of you are now commenting on in the chat box, you'll see that they've offered them their 20%. And they've come to that agreement with SAPOA, South African Property Owners Association. So it's likely that they haven't gone for that deferment, and they've made them increase that from a 65% discount to, in fact, an 80% discount. Be interesting to know what was given in return. It might be a lease extension. It might, in fact, be nothing. For May, they've said 15% rental discount and 35% rental deferment. So they've said 30, 40, 50. We want 50% of our money up front for May in terms of the normal debit order, and we'll play with the other 50%. But that's only for companies which are doing more than 80 million rand turnover. Oh, Adele says, please do the webinar on rent to sales and stock. Absolutely, Adele. Very happy to do that. We'll organize that. Alistair says something. He says, this might have been a fair offer if we went back to the 17th of April. Now with us possibly going back to the 30th, surely this is null and void and no rental for April should be due. Alistair, we're going to get to that in a minute, but you're completely correct. This, as of 2 days from now, this proposal doesn't bear any weight whatsoever. Now then, there we go. Sorry, I know you've done it privately, but I am going to read it. He says, in my case, the landlord just emailed the full rental invoice for April. No discussion at all on any relief payment or percentage discount. All right. So it's music. I'm sorry. I'm sounding so crass and like an opportunist, but that's why SAITA exists. Now then, that's why we're here. Now, we will deal with your issue. We will talk to your landlord. We will deal with your landlord, because it's providing us with a perfect opportunity. Your landlord is actually acting counter to the very directive that his associations have entered into. If he's not a member of any of those associations, the Department of Trade and Industry call him a non-party, and it's even easier to deal with him. So thank you for that, and we will certainly be discussing that. Mike, I see your point. Communal utility costs should not be paid. I understand that completely. Just before we go to our offer to them, let's just talk about the essential good services, because I've had a number of questions from independent tenants who have 1 foot in and 1 foot out. So retailers offering more than 75% essential services, nothing for you. Now, let's talk about that for a moment. I don't think any of you might be essential service retailers, but if you are, let's just talk about that for a second. What are they saying? They're saying, I run a health shop. I'm an essential service because I sell vitamins and I sell all of those good things for alternative remedies which are being prescribed left, right, and center. I'm not going to close my doors. I'm an essential service. I have a license from BizPortal as an essential service. But whereas I bought a lease in this shopping center because I was told there is so much foot traffic. I was told that very often people going to a pharmacy where there's a big queue will rather come to me when they know they can get the same product, etc., etc., etc. None of that now exists in the shopping center, where the people coming into the shopping center will be coming in because they're coming directly to me because they know I'm open, but not because they're walking around the shopping center and make a decision to coming to me as a passing tenant. In other words, what I bought from this landlord is null and effect. I might as well put a tent in the street and contact my tenants and say, come here because this is where I am. I, number one, have to market to them that I'm still open for business. A shopping center is not going to do that for me because they don't have any contact with my own customers. But more importantly, the reason I entered into this lease in the first place is null and void. It doesn't exist because it's a completely different kind of business. So why shouldn't you offer any kind of relief? I can show you that my turnover has at least been impacted by 50%, or why am I not getting 50% relief? So for those of you, and Linda, I know that your guys are a group like that in the health store grouping where you're essential services. You don't take this lying down. How dare these people tell you that even though you can prove your business has taken a major knock because of this lockdown, they're not going to give you any relief. They're making assumptions about your business which are just not true. Now, they say that if 50% of your business is locked down and 50% of your business remains operating, then the 50% that remains locked down, you can go to the block above, which is the very first block, which says SMME retailers for that 50% of loss. Now, you're not going to do that, first of all. You don't have those numbers in front of you. It takes, you're not a bookkeeper, an accountant, or an actuarial scientist to be able to do that. So if you're essential services, you're essential services, and they say they're not going to help you at all. Retailers offering essential services but electing to close, no relief offered. Now, this is very dangerous of them because now they're entering into the space that says, we are forcing you to stay open because we're going to continue to charge you rent. We're not going to give you an opportunity of getting out of your rent. We're making a value judgment that you should be open because you're an essential service. So two things. We're making a value judgment, number one, that you're an essential service. Who are landlords to decide that you're an essential service? And number two, we're making a value judgment that you should be open for business. You should put your life in jeopardy. You should put your staff's life in jeopardy. And I want to go to a discussion I was having yesterday with a dentist who said, and in fact, wasn't a dentist, he's a specialist dentist that does elective surgery. And he was saying, I'm not going to stay open for business, even though I might be able to apply to be an essential service. I don't want to, because we're working where COVID-19 lives, in the mouth of the individual. We're working in the ground zero of this virus. And the moment we enter into that cavern called the mouth, we are entering into the lion's den. But the problem is, not only are we putting our own lives in danger, we're putting the lives of our staff in danger. And more importantly, we're creating massive aerosol repercussions. What we're literally doing is we're releasing the virus into the atmosphere. So we're not going to do that. Now, your landlord has made the judgment, the moral judgment about you. You're not going to do it? Well, we're still going to charge you the rent, and we're going to say we're not offering you any relief. We're making a value judgment about your decision to close your business. Unacceptable. As far as SAITA is concerned, that's morally reprehensible. Have your landlords, has this whole pig conglomerate been commissioned by government to force you to be open? I don't think so. They've taken it upon themselves to force you to stay open. Absolutely morally reprehensible. Retailers offered partial essential services less than 75%. For the part of your business that sells essential goods, they're not giving you anything. For non-essential goods, with an annual turnover over 80 million, they'll prorate your essential goods services. So they'll play with the 80 million and aboves, but they're not going to play with you as small businesses. So they've actually said to you, tough, if you're a small retailer that is an essential service that we think is an essential service, you get nothing. Finished. You get nothing. If you do more than 80 million rand a year turnover, we'll consider giving you something on a case-by-case basis. So I don't know what you guys think. I don't know what you think, but I'm actually disgusted at the moral depravity of the South African Property Owner Association, the moral depravity of the South African Council of Shopping Centres, and the South African Rate Association for pretending that they're interested in small business when they're pandering to large business and they're completely disregarding the interests of small business on the one hand. And then for them wanting to become substantive, forcing you not to retrench your staff, not that you were going to retrench your staff anyway, but taking upon themselves a responsibility for the Department of Labor on the one hand, and then on the other hand, for the Department of Health and the Department of Trade and Industry, and forcing you to regard yourself as an essential service and to stay in business. Who the hell are these people? You should be as angry as I am when you respond to these people. And yet I'm seeing independent tenant after independent tenant saying, well, it's almost like these shopping centers are doing us a favor by allowing us to be there. It's not true. It's just that you've had no one fighting for your rights up until now. And I'm not trying to grandstand. I'm disgusted at what your landlords and managing agents think they can get away with at your expense. All right, so now let's move on. Let's look at the initial response, which we've been trying to put together as SAITA. And like I said, it's a draft that has been put together to do what it's doing at the moment, which is to get from you the kinds of responses from you we're getting to say, we agree with these things, but we're not agreeing with these other things. So Peter Muller says, who are the individuals behind PIG's name and shame? Well, you've got Neil Gopal of South African Property Owners Association is about the only person I can think of at the moment. But what I'll do, it's a good question, and thanks for that, Peter. What I'll do is I'll actually, I'll on our Facebook site, which is the SAITA's Facebook site, we'll put up the photographs and the contact details of those CEOs, because I think that they need to, they're the ones that, put their name to this document. It's disgusting. FK says independents are afraid as their stores or their livelihood. FK, I know you're afraid. And I've been an independent. I've been there as a small independent. Just for you to know, I used to own Caves, the toy shop Caves. And so I understand exactly what it means to be a small independent. And I know how you feel when you get into a shopping center that they've done you a massive favor by allowing you to be there, until you actually find out that their survival depends on you being there. But FK, I think that, we're lucky in South Africa. We've signed the International Labour Organization conventions, a number of conventions. We're very proud of that. In fact, our president is president at the moment of the International Labour Organization. We're very proud of the fact that we have what is called a social partner way of negotiating and doing business in South Africa, which is organized business and organized labor coming together with government to engage and agree on laws and rules and regulations. Now, that's good, FK, because what that means is that there is space, and now with the block release over the next couple of months, now is the time for you to work with SAITA so that SAITA becomes the organization that negotiates those templates for these agreements, that contracts with lawyers to represent your interests when managing agents and landlords are trying to take you apart. And so on the basis of a collective, a large collective, we can afford to do the kinds of things that individually you will never be able to do. And that's why we've created SAITA, to give you the knowledge that there are 10,000 retailers behind you, 100,000 retailers behind you, and not just yourself and your overdraft and your loan from your wife and your father-in-law. So that's why we've created this organization. Just before I go to our offer, I want to read Leah's question. Leah says, what recourse is there to landlords who misrepresent themselves as per Linda's comment? Linda, I didn't see your comment. I'm just going to look for your comment quickly. God, maybe I'm missing it. Cannot see it. Linda, won't you repost your comment? Okay. But she says, what recourse is there to landlords who misrepresent themselves as per Linda's comment, e.g., charge for marketing, but don't charge operational and maintenance costs, but don't maintain the center? Well, first of all, in their own document, you'll see, Leah, that they say that those operational costs are absorbed in the rental payment. So they have an obligation to keep the shopping centers clean and to maintain the shopping centers. That's part of your lease agreement. And in terms of common law, you're entitled to say, that's what I'm paying you for, Mr. Landlord, whether you express it or not. So that's the first thing. But your point about marketing costs, what is that marketing cost for? That marketing cost is there to be used to pay a public relations consultant or a marketing company at best to do so little that has such little impact on your business, and maybe is simply there for the brand marketing of the shopping center on behalf of the landlord, so that when they list the shopping center, they get a better share price because everybody knows it's Greenstone or it's Northgate or it's, I'm trying to think wherever I've been before. But the point I'm trying to make is it does nothing for you and your little business. You have to pay for the sign at the front of the building. If there is an insert into a newspaper, you have to pay to be in that insert in the newspaper over and above the marketing levy. So there's no advantage whatsoever to that marketing levy. And when things are normal again, when the lockdown is lifted, the very first thing SAITA is going to want to do is challenge that marketing levy. Because that marketing levy, no matter how little it is, should be absorbed back into your own operational budget so that we're using your marketing levy to market your business. Sorry, I know I'm on a trip at the moment, but that really is a major bugbear that I think we need to deal with. Okay. So let's move on. So the proposal says this. It says, request from your tenants during the South African COVID-19 lockdown. Dear landlord, this letter is written to you in good faith and in the hope that we can mutually avoid resorting to legal means to resolve a matter which has resulted from causes beyond the control of either yourself as landlord or your members as your tenants. Now, this is important because in their documents, they've said they want to, this is the way they want to do business. They don't want to go through lawyers. They want to sit across the table. They want to engage and negotiate. And this is saying to you, well, then fine, so do we. We want to negotiate. So number one, introduction. The SAITA is a South African Independent Tenants Association, and our non-profit company registration is pending at the CIPC, and any of you deal with the CIPC will know why. SAITA has been created in terms of Section 18 of our Constitution, guaranteeing South African citizens the right to affiliate or not to affiliate. This is critically important. It comes back to the point I was making about the International Labour Organization. So South Africa has said to the world, we're a country that respects the right of affiliation. So people can join trade unions, they can join associations, and they can work through associations anywhere they want to, which means that that association then has the right to represent the interests of its members wherever its members' interests need to be represented, in the relationship with the landlord first and foremost, but also in the relationship with the lawmakers and the regulators, with SALGA, the South African Local Government Authority, NEDLAC, the National Economic Development Labour Council. None of you are sitting at any of those tables, and yet they're talking about SMEs this SMEs that. They're making decisions for SMEs all the time where you're not being consulted. There's a policy framework around SMEs. There's an entire bloody government department around SMEs that is not giving you any benefit whatsoever because it's been created with consultation with big business, if any business consultation at all. So it's important to make the point because your landlords are going to come back and say, in our lease agreement, we say we will only talk to you as an individual. We won't even talk through your lawyer, let alone through an association. Now, because the block release has been lifted, because of the Department of Trade and Industry lifting the block release, they cannot say that to you. And more importantly, in terms of our own constitution that guarantees you the right to freedom of affiliation, they cannot say you can't join an association and we won't talk to the association. So they will try to do that and we will counter it. But basically, you have the same rights that an individual has to join a trade union and the same rights to have your trade union negotiating in your best interest to an employer. So think of SAITA as your trade union. They cannot reject SAITA insistence that it sits down at the table on behalf of its members to negotiate lease agreements, extensions of lease agreements, anything going on in the shopping center. And that's the whole purpose of creating SAITA that you have to understand, ladies and gentlemen. That's the whole purpose, the whole reason for us actually existing here, is to make sure that we push this through every time. As you're aware, the Minister of Trade and Industry, forget about that. That just goes over the history we've already gone over. So, Schedule A attached here to lists your tenants who are ordinary members of SAITA. So this is very important. I am proposing that instead of you individually going to your landlords, you go as a collective. So SAITA then says, there are 20 tenants in this building. The following 10 are represented by us. And so we want to sit across the table with you, Mr. Landlord, and negotiate in the best interest of the 10 who are our members, rather than here's a member, here's a member, here's a member. Your landlords and managing agents would prefer to deal with you individually because they can bully you individually. Our job is that we want to make sure that they have to deal with you collectively, and they do not have a right to reject dealing with you collectively. In law, it's called a dispute of interest because, in fact, no small business association has ever gone to court previously and had to prove to the court that it has a right to represent the interests of its members. But if a landlord says, we're not recognizing SAITA, then forget about the court issue of it. There are other ways of going around it. They're not going to have a right to reject SAITA's right to represent you. So our request to you, Mr. Landlord, is this. As you're aware, unless specified on Schedule A as an essential service, or that part of their operation is in lockdown and the balance trading under an essential service certificate, your tenants listed in that schedule are currently in total lockdown. As such, they have either fully or partially ceased trading for the period of the lockdown, and some or all of their employees have been temporarily laid off due to the lockdown. Ladies and gentlemen, just as an aside, it occurs to me that many of you might not be aware of the process you need to be following in how you're dealing with your staff, because many of you have come into the SAITA group as members long after we ran our webinar last week. It seems like ages ago, last week, on how you deal with your staff and the temporary employment relief fund from the UIF, et cetera, et cetera. It just occurs to me as an aside that for SAITA, we'll need to rerun that workshop so that you know exactly how you use leave, how you use the TER, and how you use unpaid leave in your relationship with your staff. Anyway, that's an aside. So some or all of their employees have been temporarily laid off due to the lockdown. Our members are in full acknowledgement that for the period of the lockdown on a month-by-month basis, the following must be paid by each tenant to you in terms of the existing lease agreements: rates, taxes, municipal services, including electricity, water, and sewage, security levies, and insurance levies. Now, the reason I'm including that in this letter is because that's what they say in their offer is non-negotiable. I'm encouraged on the one hand, ladies and gentlemen. I think on the other hand, I'm a little disappointed that not enough has been made by you collectively as members of SAITA, as tenants, that some of these should be subject to things. For example, rates and taxes and municipal services should be subject to your landlords having to go to the municipality and use the facilities the municipality are making available to them. You'll see later on in the letter, I do make that an issue, but I'm just surprised that I've had maybe 5 of you who've made these comments to me that, you know, we should be getting them to prove that they've been to the municipality, but I think we should be making far more of a case of that, because their argument about why you have to pay these things and why at the very most they will defer these things rather than allow you to have a holiday from them is that they have to pay these things. So that's a logical, reasonable argument. Except that the municipality, through South African Local Government Authority, have again and again and again said to them, we will make allowance, we will defer ourselves, tax holidays, etc., etc., etc. I have it on very good authority that very few shopping centers have in fact gone to municipalities to ask relaxations for this relief, because the attitude of the landlord is, we don't have to. Our tenants are obligated to pay these things. So why should we go and beg for for a rates and tax holiday or for a deferment when we know that our tenants have to pay these things? And more importantly, why should we muddy the water by getting a deferment, or worse, why should we get a tax holiday and then have to somehow figure out how we're going to pass that benefit back to our tenants when we're making them pay these things? So you're creating a cushy environment for your landlords and your managing agents not to have to work with municipalities. And that's not acceptable, because it means there'll be nothing for them to pass on to you as a benefit, and you will simply be paying. And they're essentially becoming the collection agencies for the municipalities in these very bad times, when the municipalities, as one of the tiers of government, is in fact, they've made the decision about these lockdowns. So I just need you to consider that, especially when we're doing a shopping center by shopping center approach to how we're going to deal with our landlords. The other thing I do want you to consider is this. Is the security levy, which 9 times out of 10 they will charge you for separately to the rental payment, is the security levy supposed to be incorporated into the rental payment, or is it separate from the rental payment? And only you can answer that. But the way you would answer that is by going back to your original rent statements that you got from the landlord and looking to see if right from the very beginning they were charging a security levy and insurance levies, or in fact whether they've simply just added them recently or over the last 5 or 10 years, depending how long you've been there. Because it's come to my attention that this has happened more and more, that they've taken stuff out of what they use your rental payments for, and they've created separate payment categories for those things. And they've done it unilaterally. They've not even discussed it with you. They've just notified you of it. Now, that again is illegal. It's a unilateral change to your contract, your lease contract. And they're not allowed to. The lease contract actually says you have to engage and we have to agree before you change anything in this agreement. So it's just something I would want you, just as an aside, to go back and look at. Because if it has happened in your own instance, you've actually got a claim against these guys. And if they changed this thing 5 years ago, and so they've been charging you 5 years worth of a security levy or even an insurance levy, whereas initially it was incorporated into the rental agreement, then in fact, you've got a case against them that they've defrauded you for a 5-year period. You can get that money back, or at least you can get a credit. Okay. These payments will be tendered subject to the balance of this request to you being accepted and agreed to, subject to a weekly report distributed to our members indicating what efforts have been made to enter into an agreement with the municipality for payment holidays and deferred payment terms for these charges. I know you're going to say what my wife says to me, those should be 2 separate sentences. Yes, I know. I went to a school that was, I think, maybe challenged in terms of splitting sentences. SAITA reserves the right to pursue against any landlord who obtains relaxed terms of payments and payment discounts on holidays, but does not transfer these benefits onto our members who are making payments for these services in good faith. I've had 2 of you who've come back to me and said, that's much too hard. You're taking too hard a stance with these landlords and managing agents. They're not going to give us a good deal if you put them on the back foot like this. I fully understand that. It might be that we need to find a way of couching this in more diplomatic terms, which we can definitely do. It would just be interesting to know what you think about this as a collective, though. Leah says, would there be strength as a collective to challenge municipal charges, etc., so that it's not in the clutter, especially if we fall into different tenant categories? Leah, not only would that be good, but it would be good not to challenge, but to actually literally go to the municipality and do the work that the landlord should be doing and saying, right, landlord, you say we have to pay the rates and taxes, but good news, we've actually got you a dispensation. We've negotiated, because you didn't bother to negotiate, we've negotiated with the Johannesburg municipality the dispensation in terms of their own rules, and we've actually spoken on behalf of your shopping center because you're entitled to that right. So Leah, thank you for that. If that's what you want SAITA to do, SAITA is only too happy to do it. And by the way, what I did omit to say when I introduced myself, besides my working experience, is that I've run a government organization for 10 years, but more importantly, I was also a city councillor. And so I understand the way local government and municipalities work. And I can tell you that municipalities are not sitting back and saying, oh, well, we're going to screw the landlords now. They've actually created the schemes to say that when you come to us on a case-by-case basis, we're only too happy to talk to you. We've got the rules, we've got the policies in place, but no one's coming to talk to us. So, Leah, you're completely correct. You're absolutely correct. Mirinda says something interesting. She says there's no transparency on any cost from landlords. Mirinda, I'm going to be so bold as to say that this is where it stops now, not because of lockdown, but SAITA, it says to its members from now on, whenever a new lease agreement or an extension lease agreement is going to be presented to you, we want to see it first. We would prefer to be in the room with you if it's possible. Collectively, we would prefer to negotiate those lease agreements on a bulk basis for tenants of a shopping center as first prize. That's what happens in the States. That's what happens in Canada. That's what happens in many countries in Europe. Associations have that ability and that power and that because they're a collective organization. That's why the International Labour Organization was created in the first place, to create these social collectives. And certainly our government can't, on the one hand, be president of the International Labour Organization, espousing, social partnerships. But on the other hand, say that landlords are entitled to say, we're not talking to a collective, we're going to talk to each tenant one by one. So 100%. All right. Karen had a very important question. And sorry, and I'm talking politics. It's the wrong time to talk politics because you have your own issues to deal with. Karen, yours is an issue. If I manage to pay my staff in full, would the argument of not paying rent be negated in any way? Can they request staff payment information? Well, first of all, if you accept their terms, yes, they can. And I'm suggesting you don't accept their terms. But Karen, more importantly, I'm sure you know about the temporary employee relief. Now, what they do say in their proposal somewhere is that you've got to exhaust all mechanisms for funding, and they include there from the UIF and Department of Labor. So they're actually saying to you that the argument you're using, that I want to pay my staff first, they're saying to you, in fact, exactly what we're saying to them about the municipality. They're saying to you, prove to us that you've gone to the UIF and applied for TER for your staff members, so that when you say you can't pay rent, it's not because you've paid your staff members but haven't set off the TER or what you're expecting from the TER, from the UIF TER fund to offset against what you pay your staff members. So they're using that same argument. That's why I'm comfortable using this argument about municipalities against them. But what we will do, Mirinda, is run a separate workshop on how you apply for TER with the UIF and all the other things you can do as far as your staff are concerned. We'll have to do that. Okay. In tendering the above, we also request that you consider on a case-by-case basis our member application to you for deferment of these charges, should the tenant's current cash flow not allow them to make these payments to you. We would welcome the opportunity of engaging with you further on conditions, criteria, and repayment terms, which you would choose to apply in this regard. So, as you can see from their document, they've said to the 18 millions and aboves, we'll allow you to defer what you owe us. So we're saying we want the same right. Thank you very much. We've got to say that because they've basically said we're out of the picture in terms of that offer. On behalf of its tenants, SAITA disputes the need to either pay the marketing levy or any parking levy which may be applied. It is SAITA's contention that there is no value to be derived from paying a marketing levy during lockdown period, and that should there be a need to engage in marketing activities, these costs should be absorbed within the operational budget of the property business. In simple terms, as the client of the property owner, our member has entered into a lease for the rental of a unit in a property that has acceptable footfall, is properly maintained, and is attractive to destination clients and passing trade within the complex. Rentals received should be more than compensate for creating such a framework, which then becomes attractive to tenants to invest a large proportion of resources in to set up the shop. So ordinarily, that's why we'd pay rent. So why do you now want a marketing levy on over and above the rent? As for any parking charges, it goes without saying that our members refuse to pay any parking fees for parking spaces that are not able to be used. Any other agreement would amount to unjust enrichment at the expense of our members. Now we get to rent, but before that, any questions? And again, I apologize for the fact you have to type your questions out, but let me just take 2 questions, or 3. Leanne says the block exemption restricts the categories exempted in Annexure A. What about tenants who do not fall into these clearly defined designated retail tenants? So, Leanne, I want to say to you that there is absolutely no way that the DTI would discriminate against tenants in the same shopping center as the tenants for the block release, but that they would have to prove a case of collusion against. They just wouldn't take that chance. Understand that the reason for the DTI doing the block release was not because Ibrahim Rasool, our Minister of Trade and Industry, who, by the way, used to be the main clothing industry's trade unionist, who closed our clothing industry down in the country, but because it's not because the Minister of Trade and Industry, Rasool, is the guy who said, I want to initiate a block release for the property owner sector. SAITA and the other guys came to him and said, we want a block release. And these are the companies we want to protect in our blocks, in our shopping centers, at all costs. So the categorization of who the block release was for was really only because the large shopping center groups like SAITA and Rates and the other guys have never spoken to you. They actually don't know you exist as small and independent tenants. So when they gave to the DTI the list, the classification list of who should be included in the block release, it's only because that's who the big guys are. The big guys don't do what you small guys do, or at least they don't classify it like that. So the DTI knew no better. And certainly because of the extension of the lockdown now, we will be going, the SAITA will be writing to the DTI and asking for that block release to in fact be extended. Because you're quite right, the way it is at the moment, it doesn't make sense. So I hope I've answered that question. Mr. Desai says, I am the only, hopefully we can work together on that one, Mr. Desai. Marinda says, if the landlord can pass the buck to us to pay, can we not counter by asking them to use their dividends to assist us? Well, Marinda, in the case where your shopping center, for example, Sasol Pension Fund, is part of a listed property, it's on the stock exchange, then certainly you could appeal to the stakeholders, the people who own the shares of that business, to come to your protection. Of course you can. Leah says, if our landlords find out that we're now part of this association, which doesn't bother me, otherwise wouldn't be here, but we feel they start discriminating against us as independent tenants, I mean, Leah, unfortunately, you know exactly what I'm going to say now. I would love for that to happen. I would love for them to try and discriminate against you because you are using your constitutional right to affiliate. It would put them in such a bad space that they would literally be compromised with trade unions. They would be compromised with government. Government wouldn't be able to come out in their defense after a block release when you're asserting the right of freedom of association. So yes, it's quite possible, but they need to be brain dead to try and do something like that, I need to say. And by the way, that wasn't a negative comment about people with disability. It was just about a comment about people who just don't think on their feet. Right. Yolanda says, I heard from a previous tenant that our center doesn't charge us electricity as per the municipal invoice, but adds it to the amount that they are not, and therefore they're not competitive with other centers. Well, that's absolutely fantastic. That's very good of them. I don't think there's anything we can say about beyond that, Yolanda, but if it's true, it's fantastic. Adele says, yesterday News 24 indicated the peak of COVID could be in September. Yeah, that's true. In fact, I sent that article on the groups again. Peter Kilpin says, we've already paid rent for 5 days in March under lockdown, so essentially we must also deduct 5 days from the May rent collect. No, you haven't got an agreement, Peter. So you can act unilaterally, in other words, without an agreement with your landlord and hope they won't pursue against you, or we can get an agreement. The reality is it's highly unlikely they're going to agree to anything for March. But I think there's a different argument to be made, though, and that is these landlords knew that the virus problem was there long before the lockdown. In fact, at least a month, if not 2 months before the lockdown. The question is, what did the landlords do in trying to deal with the management of the virus in the shopping center? Now, it's quite true that under lockdown now, they've put up tables, they're spraying people, etc., etc. But did they do that 2 months before? And it can be argued that your turnover dropped from February, not from March. And therefore, we have a case for some kind of credit to be passed by them for losses incurred, not through any fault of their own, but for losses incurred because of this virus at that stage. But that would need to be a separate action that we would consider against them, Peter. It wouldn't be part of this negotiation. Melissa says lockdown doesn't mean locked out, therefore rent cannot be withheld. That's interesting, Melissa. Lockdown doesn't mean locked out. Lockdown means that your business has to be locked down. It means that you are not in, unless you're, and the president was quite specific about this when he first announced lockdown. You're entitled, let's say you've got a machine in your business that cannot be switched off or that needs regular maintenance, otherwise it's going to break. Or you need to clean your business because I don't know, you have malicious chemicals and very dangerous kind of things you sell in your business. Under those circumstances, your doors have to be closed, but you can allow in a specialist cleaning team, or you can allow in a maintenance team who goes in and services your machinery and equipment, because you can prove that if it's not serviced or run, for 12 hours or something like that, it'll break. You can justify, we're not an essential business, but those kinds of things can take place in the shopping center. And the landlord can elect to allow that to happen or not to happen. But locked down means locked down. So even if the shopping center is open, who's it open to? Melinda, you seem to be implying, sorry, Melissa, you seem to be implying that because you can walk into a shopping center that's open with lockdown shops, that the landlord should be paid for the lockdown shop to be there. It's not logical. There's no benefit that the tenant is deriving from being in a lockdown shop. In fact, from not being in that lockdown shop, because the shop is locked down. So I'm not understanding your argument, Melissa. Of course, we're not suggesting the withholding of rent. We're suggesting a negotiated agreement for rental discounts and for deferment of rent. So there's a big difference here, and we have to acknowledge that difference. Bill says, you keep referring to the DTI. Where's the SMME ministry in all of this? Bill, that's such a fantastic question. I think a better question is, who is the SMME ministry? Because they quite frankly don't exist, but that's for a different day. But yeah, the SMME ministry as well. But we are licensed under a regulatory framework governed by the Department of Trade and Industry, not by the SMME ministry. We only look to the SMME ministry for relief, and we don't find relief. Peter asked a good question. No, Peter, don't do that. That's nasty. Certainly, Melissa, please, I never implied what Peter is implying. Mashuda says, does this apply to small office blocks as well, not only shopping centers? Interesting, Mashuda. So Mashuda, SAITA is saying that we want to represent everybody who's a tenant, whether they're in an office block or they're in a shopping center. There should be no difference, because your business in an office block is shut down. And in fact, you will see from the PIG proposal, the pigs themselves say that we are encouraging people in office blocks and industrial parks, etc., to have the same discussions with their landlords, asking for the same kinds of dispensations. So the pigs themselves appreciate that and have acknowledged that. I'm sorry to use that acronym, but that's who they said they are. They say they're the property industry group, and so they call themselves pigs, and that's who they are. Right. Melissa, you're absolutely correct. It is a concern to reflect on. Adrian says, currently I'm the, okay, fine, that's fine. Melissa says, it's an argument from a landlord she sent in an article. Absolutely. Melissa, you're quite correct. That's the argument the landlord's making. And there's another argument the landlord's making, and that is that even though you're locked down, the shopping center is open. And by the way, we're allowing you to store all your product in the shopping center. So we should be entitled to compensation as a storage facility. That, in fact, is the reason that the large truists of this world have said to them, right, we'll pay you 20% of the lease as a storage facility, because there's no other benefit we're getting from you. Now, when it comes to our offer on the rental, it could be an argument for why we would offer anything on rental payments as a storage facility. And Fulvio says, highest trading days of March after payday due to lockdown lost. Can this be brought into the negotiation? It can definitely, Fulvio, when we look at a secondary claim against your landlord, it would be for losses incurred, not through any fault of their own, but for losses incurred because of the pre-lockdown period. It's a more difficult argument to make because we don't have law on our side, but it certainly is a dispute of interest, which, if there are enough of you, becomes a collective interest even the Constitutional Court might be interested in. But that is for a different day. All right, so let's now get to what we're offering in terms of rentals. Rental payments. As the businesses of our tenant members are closed due to lockdown, there's no benefit to be derived from occupation based on the clauses and terms in the original lease. Benefit is simply not there to be derived. Therefore, our members your tenants, are not in any position to earn income or pay a percentage of that income in lieu of rent. SAITA is, however, encouraging our members to offer 10% of the current monthly rental charges in good faith and as a sign of respect to the landlord, an acknowledgement that while our members are severely impacted on by this lockdown, so are the property owners. Now, I know this has caused consternation amongst you, our members in SAITA, because some of you said we should offer 20%, like the large groups are doing. Some of you said we should offer nothing. And you feel very, very strongly about this. We are saying that if at some stage we encourage you to withhold your rent because we have tried to do everything honorable and the landlords and managing agents have rejected what we've offered them out of hand, we're saying that if a court ever looked collectively at that kind of an action, or the DTI did, or Competition Commission did, then by us offering a token 10%, we are in a better position to have been adjudged to have had a genuine offer on the table than by us offering nothing at all. And that 10% could very much be judged to be covering things like rental for space, for storage space, more than anything else. So I would appeal to you to understand, yes, and we can do this on a shopping center by shopping center basis. We can vary any of these clauses. But I would appeal to you to understand the strategy in offering that 10%, ladies and gentlemen. In this regard, we're pleased to see relief being offered by banks and financial institutions, which will, we believe, go a long way towards assisting property owners in riding out this lockdown. We also encourage property owners to speak to your insurance companies to determine what insurance cover you qualify for, because they've said this to you guys. They've said you should go to your insurance company and talk about business interruption. We're saying the same thing to them. Encourage you to speak to your insurance companies to what insurance cover you qualify for in the category of business interruption or loss of income, subject to your having accommodated for force majeure and acts of God. Because this is what they're telling tenants. They're saying it's your fault you didn't have the right insurance. SAITA is pleased to offer advice and assistance as a sign of goodwill to any property owner who may wish to consult on the subject. And we don't say that in a joking way. If they need advice, we'll give them advice. D. So that's our rental that I'm suggesting we seriously consider offering. D. Recovery after the lockdown is lifted. If lockdown is lifted at the end of April, SAITA maintains that it'll take a minimum of 3 months for our members to fully recover. The reason I said 3 months, ladies and gentlemen, is you guys told me that's the average time you're anticipating. And build their businesses back to where they were in January of 2020. For this reason, we're requesting a staggered schedule be applied to the rental payments for those 3 months as follows. May, 35%, June, 50%, and July, 75%. And for each month that lockdown is extended, the period is staggered. Repayments will be pushed out by an equal amount of time. I put in a section here called Landlord's Recovery. Now, I put this section in because we have to limit in some way the fact that many of you across the country are getting letters from your landlords. I suppose the ones that the landlords do want to communicate with. But you're getting letters from your landlords that have all kinds of interesting offers. For example, they say to you, if we give you a dispensation in April, let's say we give you 50% reduction. If we give you whatever we give you for April, we expect you to sign a year's extension on your lease agreement. If we give you May, we expect you to sign an additional 2 years extension. So for April and May's dispensation, we want a 3-year lease extension. They're making that a condition of their offer. So in response, and it's happened on at least 6 occasions that you've told me this, and I've seen the documents. So to put a stop to that, we're saying to them this. As your tenants, our members recognize and acknowledge your own financial exposure during this state of lockdown. We therefore, in good faith, tender the following. That for every month of lockdown and the recovery period of 3 months, we calculate thereafter, our members will agree to extend the existing lease for the identical period. Thus, with a 2-month lockdown and 3 months thereafter of staggered rental payments, those 5 months would consequently be added on to the existing lease, which our members operate under. We would, however, not accept any upwards increment or escalation for the period of the extension. So without me saying it, I hope you've read between the lines. There are two things. Well, let me say it. There are two things here. Number one, they're going to come back to you with an extension of the lease because they've done it across many shopping centers already. And we're wanting to limit that because they're saying they need to recover their losses. And we're saying, fine, fair enough. But if we have a month of a lease extension, then whatever you've given us for a month, you'll be able to recover. But there's something else I'm doing here. Some of you have said we don't know if we can afford, because of the escalation, if we can afford to extend our leases. And I'm saying to you, if they accept this offer, they will have deferred any escalation for the period of that extension. So it means we are buying you a reduction in your existing lease of it being escalated for whatever period we agree on the extension being for. It's a small benefit, but it is a benefit ultimately at the end of the day. Leah says if they offer deferments or reduced rentals for the next few months, are they allowed to charge interest on what on the actual amount should have been for this time? So Leah, the answer is that they can offer, and in their offer they can say we're going to charge interest. We have to reject them charging interest because the bottom line is you've got no income that you're making. Now, the next one, F, is very, very important. A number of you have contacted me saying that our landlords have already told us that they're going to evict us or threatening to evict us if we're not paying in 7 days. So what we want from the landlords is this. And they actually don't have a right to not give this, by the way, because, again, it's in the block release. A cessation of prosecution. We call it nulla prosecutore. What that means is, for this packaged offer to be accepted, we require formal acknowledgement from you, the landlord, that you will not pursue any form of prosecution or suit against our members for any performance outside of this agreement in terms of clauses applicable in the pre-existing lease agreement. This includes no application for summary judgment, no application for attachment orders, no locking and shuttering exercises, no blacklisting, and that you will not withhold the opportunity from any of our members to extend the existing lease agreement in terms of clauses contained therein. Now, I know that this is on many people's minds. And what I'm saying to you is we do not want an agreement with a landlord if they're not prepared to be genuine in giving us this undertaking. Amit says, we are a luggage store. 60% of our sales are travel bags, and we don't foresee many people traveling this year. Amit, that's very important. We might have to have a separate engagement with your landlord in that regard, sir. So if you're a travel business, like a flight center, if you're Amit, if internationally, so the issue here is what's going on globally, not so much what's going on here. If globally the lockdown continues to September or October or even, God forbid, December, then Amit, essentially you're dead in the water unless you can rejig your business. Yes, you can go to small business, you can go to business partners, and we can talk about that individually. But essentially you're dead in the water if you depend on the travel business, which means we have to have a separate kind of a negotiation. I'm almost inclined to say, Amit, we need to have an industry discussion. You need to get as many of your kind of people together as possible who sell luggage or in the travel business, and we need to look for a different kind of a solution. I think I told you in one of my webinars previously about the Danish hairdressing example, where the Danish hairdressing trade union took the Danish hairdressing sector out on strike for 10 years. And in the process, they completely replaced the Danish hairdressers with their own members and built businesses for their own members. Now, I'm suggesting that in the travel sector, it might need as revolutionary a solution as that. But we'd certainly have to have a discussion with your landlord, nevertheless. You are in a very invidious position, and I'm very happy to work with you to knit everybody together so that we talk with a common voice. But it's a different discussion. Chris says, don't get too distracted about deferring your payments. It is a nice offer, but might be a way of not addressing the fact that remission might be due. Yeah, I completely agree with you. I think deferment is a red herring, Chris. It's a red herring unless it's properly negotiated, because it's going to cause you a massive cash flow crisis when you have to be paying it back when you're trying to get back on your feet anyway. So I'm completely in your camp there, Chris. I completely agree with you. Marinda says, Ivor, we need to evolve in this industry. We are just maintaining status quo of long leases. Trends are changing, and we should move into other shorter periods and easier entry into or exiting. Yeah, I agree with you. That's why SAITA now exists. For me, the best lease I have, by the way, and I still have leases, but the best lease I personally have is with a shopping center owner who has agreed to a percentage of turnover clause, which is restricted to 7%, which means then that I don't pay outside of the normal rental expenses of rates and taxes, etc. My actual monthly payments are based on percentage of turnover and pegged at 7%. Now, I have no problem paying 7% of my turnover when business is good. I have a huge problem or ability to pay 7% when, or to pay a standard rental requirement when business is bad. And my business is very seasonal. One of my businesses is very seasonal, very much holiday related, just like Amit. And so in that regard, it's feast or famine. And yet rental becomes a constant in that business if you don't have a percentage of turnover clause there. And so, Marinda, what I'm saying to you, or Leah, yeah, it was Marinda, what I'm saying to you is absolutely we need to talk about. Landlords say we don't do percentage of turnover clauses in lease agreements anymore. Well, it's tough. Business has now changed. And we could even say to them, you know, when it comes to that clawback period of us getting back on our feet again, instead of a set lease amount, even if it's 35%, we want a percentage of turnover, which means we're quite happy to have our turnover audited as we're getting back on our feet, because we know that it's going to take a long time for that turnover to reflect the kind of payments that the landlords are going to be interested in. So, Marinda, thank you for that. Lana says something very interesting, and I think many people agree with her. She says, personally, I think 3 months is a really rosy outlook. We should expect 4 to 6 months. Yeah, no question, Lana, no question. You know, we're trying to be positive here. All right, but I agree with you. Next one. I don't know. It might only be one shopping center I've encountered this, and so I've taken the liberty of putting G into this proposal to them. But you do need to consider it because it's as far as I'm concerned, it's fraud. What's happened in a particular shopping center is that the landlord has said, we've got great news for you. We are going to the World at Large. We're going to use your marketing levy to go to the World at Large and ask them to buy vouchers from you in your businesses. We can ask them to prepay for services so that when we're out of lockdown and you're open again, they can come to you for a haircut and then bring the voucher to us and pay for the haircut. Okay. And then they say to their tenants, and we will then set the money we've collected off against what you owe us for rent. In other words, we're implementing a voucher system to pay ourselves. You're going to have to work the vouchers, offer the services for the vouchers. So it's very much like a deferment kind of thing. We'll defer your entire rental statement, but then you'll work for the rest of your life paying us off before you actually see a cent of your money. I mean, I'm taking a breath because of how fraudulent I think that landlord is being. And if you don't come back to us by Monday, we take it, silence is acquiescence. You've agreed to the scheme. So we're saying here, don't be stupid. If you want an agreement with us, then a cessation of the introduction of any program designed to assist the landlord in recovering rentals from out tenants unfairly. It has come to the attention of SAITA that some landlords are implementing a voucher system whereby, funded by the marketing levy paid to date by our members, landlords will sell vouchers to existing customers and clients, whereas proposed by those landlords that they will retain the revenue generated from services performed by our members after lockdown for the purpose of set-off against rentals accumulated during lockdown. As part of this package offer, SAITA demands that those landlords immediately desist with such action, failing which SAITA shall report those landlords to the authorities. SAITA views such action in the same light as price fixing and price hiking. I didn't say this, but as you know, there are people who are currently up before special courts. The courts are not normally working except for these people in terms of price hiking and price fixing and jail terms. And in fact, some of them have already been imprisoned. Because I don't know about you, but I think that's absolute fraud when a landlord does that. So lease renewals. In this instance, where a SAITA member has a lease with yourself, which is up for renewal, we request that the entire renewal process is stayed. In other words, we don't want you to force our tenants, members, to renew until after the quid pro quo extension process detailed above. In other words, not when lockdown is lifted, but until after the period of the time that we agree on it should take them to recover, whether it's 3 to 4 months or 4 to 6 months. So we don't want you to push them for a lease renewal until they're back on their feet again. And we want you to have to operate on a month-by-month basis. Next, the package. For any agreement discussed with SAITA to be acceptable to our members, your tenants, we will need to agree that this is a package proposal and that we cannot permit any cherry picking to take place, which means that you choose this, but you say no to that and you change that. At least not unless it's properly negotiated with our members. Now, as SAITA, I have a job to do, and my job is to make sure that whatever negotiation takes place in a particular shopping center to get the landlord to agree to agree doesn't at the same time set a ridiculous precedent for you, the tenants, that you feel forced into, but equally doesn't set as much of a ridiculous precedent for other shopping centers, either with the same landlord or just as a precedent that SAPOA or any of the other associations could try and apply. So it very much is a balancing game, and that's the role that SAITA needs to play in this game that you need to understand. So there is a negotiation tactic or a negotiation formula which talks about a package deal, and we have to stick to the fact that this is a package proposal and that we don't ordinarily want them to be able to cherry pick the package proposal apart. We look forward to a healthy engagement with yourselves in an attempt to resolve these issues and thereby ensure the rebuilding of the center is in the best interest of yourself as the landlord and SAITA members who are your tenants. So, ladies and gentlemen, that's a long way around getting to the fact that, as you can see, we've taken a little bit of time to put together a proposal that isn't the same proposal that the pigs distributed, but at the same time is a proposal, quite frankly, which I think is far more in your best interest than just accepting the pigs proposal. The property industry group itself, as I said, which is made up of the shopping center owners, the South African Property Owners Association, and SA Rates, are on the back foot in the sense that they've already compromised with their own proposals to their own members when you see an agreement like the Fashini agreement now being entered into. They are going to have to extend that agreement if they're serious about the agreement to the full period of the lockdown anyway, and therefore change what they're offering. We await with eager breath to see it. My honest advice to you, my members, is to say to you, guys, don't wait for them to come to you. Go to them, because then they will need to respond to your offer. If you wait for them to give you an offer, we're always responding to their offer. It just puts you in a position of strength to be able to come back on your own offer rather than the other way around. I understand this sense of loneliness you feel, and therefore this sense of lack of self-worth, that it's not an equal relationship you have with your managing agents or your landlords, but you do. And that's why SAITA exists, to give you that power. And I need you just to understand that. I need you to understand that you have that power. Marinda says, well, what is the next step? Guys, I think what I want now to do is this. I want you, if you're in a shopping center where we haven't had a shopping center discussion, in other words, we haven't spoken to the tenants of that shopping center, because maybe you're the only tenant who's a member of SAITA anyway. But I need you urgently to take it upon yourselves for us to have a discussion like we're having now, but only with the tenants of the shopping center. We've done that with a couple of shopping centers, but not enough. And to determine what you want to see changed in this proposal, number one, and then what SAITA is going to do in terms of taking it to the landlords and therefore saying to the landlords, we're here, these are the tenants we're responding for, and this is the discussion we want to have. So in answer to your question, I think we want to do it on a shopping center by shopping center basis. If you're, for whatever reason, a lone tenant, you're on your own and you want to deal with your landlord, then simply indicate that to me by an email, and we'll begin the process of email negotiation to get an offer to your landlord drawn up, and then to get it to your landlord so that your landlord has to respond to us and put your landlord, put it in your landlord's court. So in either event, we want to get to that stage now. I think you need to act sooner rather than later. In other words, I think that you need to have completed your consultation process with me or whoever you want to be consulting with by Friday, so that at the very latest by Monday, there is a proposal to your landlord, because there's obviously going to be a negotiation period. Ideally, you want to get it before Friday. What we want to do is we also want to create public interest in SAITA's response. So after listening to you, taking everything into consideration, and most probably until about Thursday, taking your feedback again and again and again, we will go public to the media with a response by Friday to say that this is the Independent Tenants response to the PIG proposal, because that's very important. What that does is it says to the Department of Labor, Department of Trade and Industry, and the other government departments, expect a call from SAITA because a shopping center owner is refusing to engage or negotiate with SAITA and is insisting on negotiating on a tenant by tenant basis, and intervene. In fact, I know that they've actually put, funnily enough, the CCMA on alert for that kind of an instance. But this isn't a matter of labor, but the CCA obviously have the widest spread of negotiation skills. So either your landlord is going to say, great, or your landlord's going to say, look, we have to change some things and here's the reason. Or your landlord's going to say, bugger off, we don't want to talk to you. We're going to talk to our tenants individually, in which case we have to make a case. In labor law, funnily enough, it's actually called a case for recognition. And there are laws in this country around being able to sue an employer to recognize a trade union. We might have to do exactly the same thing. We might have to sue a landlord to recognize SAITA's right to represent your interest. I pray it never gets to that, but it might. And if it does, there are more than enough lawyers out there who I've now identified who would be prepared to do that kind of suit on a pro bono basis, because they would get onto our list as SAITA and be able to offer their services to you, our members, into the future. But yeah, these are all things we have to consider. Leah says this: tenants in our center were already battling to trade due to the deterioration of the center footfall, tenant mix, maintenance, etc. So I truly believe that they were on the back foot before this all happened. Coming out of this, they will then battle to recover, because the landlord isn't doing anything to fix the situation. How do they negotiate this? Because this will be a longer process for them, way beyond coming out of lockdown. So I feel that these tenants have a bigger problem. This is a good time to negotiate even harder on this. Leah, I completely agree with you. Completely agree with you. And remember, SAITA doesn't exist only to deal with lockdown. SAITA exists to say to you, now we need a strategy for dealing with the landlord on these issues. It can be at the same time, it can be simultaneously, or they can become consecutive engagements and negotiations. But I'm definitely wanting to work with you, Leah, on making that happen for your shopping center. Linda says, thank you, Leah. Jeez, I hope I'm not thinking that that's the shopping center you're talking about. I'm sure it's not. Okay. Warren says, please can you share an email address so I can advise all the centers I am present. Okay, Warren, I'm actually going to type it. It's here on this slide here. So let me put this slide up. But it's on this slide here. These are my details. Ivorb, IVORB at ARC, ARKKONSULT.com, ARCconsult.com. Ivorb at ARCconsult.com. That's my private email that you can send it to. I'm only too happy to engage with you. Mark says, will we be sharing the webinar? Yeah, we'll share the webinar. Absolutely. Oh, Linda, you've said yes. That really makes me despondent, but you know why, but that makes me despondent. But we need to take that up then urgently. I can understand the shopping center, for argument's sake, in the south, that is always going to be in trouble simply because of the LSMs changing geographically, demographically, whatever it is. I cannot tolerate the concept that there is a tenant in one of the most upmarket shopping centers in the world that is being neglected by the landlords, the way Leah is describing. So sooner rather than later, but very certainly. Adele says, my husband, legal advisor, construction. Yeah, absolutely, Adele. Let me just explain one thing to you, Adele. I put out a call on LinkedIn. I put out a call on Facebook previously because I needed us to find lawyers who have not done work for shopping centers or managing agencies. And so you can understand that every large legal company in the country, whether it's, well, any large legal company in the country, they've built themselves up. They have those fancy buildings in Sandton because they've all done conveyancing and they all act for managing agents and they all act for landlords. They do not act for independent tenants. But there are a very good smack of lawyers out there who do not act in conveyancing or in the property sector, etc., that we are actually including in our list. So I very definitely want to talk to you, Adele, about your husband. Thank you for that, because we need those people and we need them to be available to you, the independent tenant. What happens when we start negotiating and the lockdown extends further? Well, FK, the longer the lockdown extends, the better our case is for the compromise we're trying to eke out of your landlord. Would the months that we offered still hold, or can we negotiate further? No, in our offer, we actually say, that if the lockdown is extended, then this thing moves out. So very, very definitely, we actually do say that in the offer. Good. Well, ladies and gentlemen, I do apologize. We started this thing at 9 o'clock. It's now 11 o'clock. So it's 2 hours we've taken rather than 40 minutes, 45 minutes. I really do apologize, but I hope you found some merit in it. The fact that 74 out of 86 people are still on the line now, some 2 hours later, tells you how important this is in your life. I really, really, really need you to focus on putting together a center by center approach to how we talk and when we talk again. And please, I'm trying to make myself as accessible and available to you as I can possibly do. So please just feel free to contact me either on WhatsApp. You've got my WhatsApp number, or in the group, or email me now, because you've got that email address. I'm going to give it to you again. It's IVORB, IVORB. That's short for Ivor Blumenthal, IVORB at ARKConsult, ARKKONSULT.com. My company, ARK Consult, was created to become an ARK for the business community, specifically you guys, because as independent tenants, you are out there in the ocean on yourself. And the purpose of ARK Consult is to make sure that that stops, and it stops now. So thank you all. I really appreciate it. I really appreciate the time you've taken. I hope you haven't found it a waste or too much repetition. And please, I will certainly, on the financial management side that we spoke about, the ratios, etc., I will be organizing that webinar for you. And then also the I suppose the staff management issues and how you use the unemployment insurance fund. I will be organizing a separate SAITA webinar for that as well, because I think that's critical, critical for everybody concerned. So thank you again, and I look forward to continuing to interact with you and for SAITA to become real in your lives. Because at the moment it's in your mind only formation, but I want it to become real in your lives. I want it to become a resource in your life. The purpose of any association is to offer maximum services and drive the cost to you of everything down that you'd individually need to be buying as a business for non-core services that really have nothing to do with the way you run your business. So that's why we've created SAITA, and I hope you will eventually see value in it. Thank you all. I've really enjoyed that, and yeah, let's just keep working.